Welcome to this YouTube educational series on the termination of marriage in Ohio. Please note that this is an educational video series only, does not constitute legal advice, and does not create an attorney-client relationship. First off, let's touch on the concept of marriage. Marriage is a legal and personal relationship. The Ohio Revised Code sets forth statutory provisions for creation of marriage. Ohio recognizes marriages from other states and countries if valid in the jurisdiction where solemnized comity, full faith and credit. Regarding same-sex marriage. In the 2015 case of Obergefell v. Hodges, the U.S. Supreme Court has held that same-sex marriage is valid in all states. However, the Ohio Revised Code states that marriage is between only one man and one woman, and a same-sex marriage has no legal force and is not recognized by this state. Common law marriage. After October 10, 1991, common law marriage is prohibited to establish marriage in Ohio. Service must be perfected to invoke the jurisdiction of court, otherwise the judgment is void. Let's discuss the legal process of divorce. The plaintiff must be a resident of Ohio for 6 months immediately preceding the filing of the complaint. The plaintiff must be a resident of the county at least 90 days immediately preceding the filing of the complaint. This requirement may be waived if both parties consent. Now, the court may have only jurisdiction over property if the defendant has no connection to the state. The court has authority to grant a divorce, but cannot issue any orders on the defendant. A court may proceed with a divorce if the plaintiff dismisses a complaint, but the counterclaim remains pending. A case may be stayed by bankruptcy, mediation, or conciliation. The grounds for divorce. The Ohio Revised Code lists fault and no-fault grounds. First, the fault grounds. There are several, but the most common are willful absence of an adverse party for 1 year, adultery, extreme cruelty, gross neglect of duty, and habitual drunkenness. The no-fault grounds. Parties have lived separate and apart for 1 year. Incompatibility, unless denied by either party. It is important to note that grounds are not a factor considered by the court in deciding property division, spousal support, or custody. How is a divorce case commenced? Either spouse may file a complaint for divorce. The non-filing spouse may file a counterclaim, and the case's commence of service on the non-filing spouse is perfected within 6 months. What are temporary orders? After a divorce case is commenced, the court may issue temporary, provide for temporary spousal support, child support, parenting orders, and division of household expenses. Usually the court will conduct a hearing before issuing temporary orders. The case moves forward then to a final hearing after a required time frame. At the final hearing, the party's testimony must be supported by other credible evidence. Next time, we will discuss dissolution of marriage versus the divorce process. Please like and subscribe to my YouTube channel for more educational content on Ohio's family law.